So thank you all for joining us this afternoon. My name is Sarah Gebremoussa. I'm an assistant professor here at the Allard School of Law. And I'm also serving this academic year as the interim director of the Center for Law and the Environment. Before we begin, I want to acknowledge that we are gathered on UBC's Point Grey campus on the traditional, ancestral, and unceded territory of the Musqueam people. This place has long been a site of teaching and learning for Musqueam, where knowledge, culture, and responsibilities to land and water have been carried forward across generations. I'm grateful to be able to work and learn here, and I also recognize that a university gathering like this sits within an ongoing colonial history that has not ended. And that context matters, of course, for today's conversation. The Gitxaała litigation asks difficult practical questions about how Indigenous rights and authority are treated in decision-making about lands and waters, and what justice and accountability can look like when mining, governance, and law collide. So I hope we can hold this discussion with humility, care, and a real willingness to listen. And if you're joining us online from elsewhere, I invite you to take a moment to acknowledge the Indigenous people on whose territory you are today. So, as I mentioned, we are gathered here today to actually discuss the landmark Gitxaała and British Columbia BC Court of Appeal decisions. Today's event is co-hosted by Indigenous Legal Studies, the Indigenous Law Students Association, the Center for Law and the Environment, the Environmental Law Group, and the UBC Future Minerals Initiative as part of Indigenous Alliance Week. And we are so pleased to welcome Jessica Clogg, Executive Director and Senior Counsel at West Coast Environmental Law, who's here with us in person, as well as Ruben Tillman, Associate at Fong Lawyers and Counsel for the Gitxaała Nation, who's joining us virtually. So together they will explore the decision's significance for Indigenous rights and its implications for the future of BC's mining laws. So both of them will speak for roughly, I'd say, 20 to 25 minutes, and then we'll have time for questions. For those online, there should be instructions in the chat about how to pose your questions, but if not, we will post a reminder. So if you will all please join me in welcoming and thanking Jessica and Ruben for joining us today.
Thank you so much for having us and for the land acknowledgement. Always the place that we begin, just recognizing and feeling our connection to the land and water that sustain us, and recognition of the peoples who have stewarded that since time immemorial. We have some slides that we'll pull up here in a second. Briefly, Ruben and I are both part of the legal team for the Gitxaała Nation, who together with the Hattahsack First Nation were the applicants and then the appellants in this case. Ruben, you want to just pull up the slides?
Yes. All right. Okay.
Next slide. So often here at the law school and in our legal research, we read cases and we get quickly to the legal principles, to the things we need to know to understand the law and apply the law. But I wanted to begin first with a reminder that I hope that you as students and later as lawyers will never forget, which is that every case is the story of the people. And here you see a number of the Simgiget and Sinamahana, the chiefs and matriarchs of the Gitxaała Nation, alongside representatives of the Gitxaała hereditary chiefs and the Nuhawk Nation, who were interveners at the BC Supreme Court level. So that this case, as with all Indigenous rights litigation, is a story of a people, in this case, the Gitxaała Nation, choosing to come to the Canadian courts for justice, but ultimately to hold up their own law and their own jurisdiction to care for their people and territory. Next slide. And this case in particular arose because of mineral claims that had been granted on Lac Nagazal, Banks Island, sometimes described as the breadbasket of the Gitxaała people. And I invite you to just sit for a sec with the beauty of this place, which is the land on which the story of the case began. Next slide. And the story of this case is also rooted in a mining disaster. These images are from the Yellow Giant mine, a contaminating mess that was left in Gitxaała territory. And we go back a number of years when Gitxaała discovered that in addition to the crisis they were already facing with the poor mining practices and contamination associated with this mine on Banks Island, that a swath of new mineral claims had been granted to third parties, to miners on the territory without notification, consultation, let alone consent of Gitxaała. And it was in the process of the need to stand up their own laws to rectify the harm that had been done. It was the recognition of this gold rush era mining law, which was at the root cause of the harm, the theft of their resources and the harms that had been done in this mining disaster. Next slide. So to ground us further, we're going to briefly play first an opening prayer from Simoget Nisaiwas, who was the named applicant for the Gitxaała hereditary chiefs in this case, and some opening remarks from Chief Counselor Linda Innes. And these are from a webinar that we hosted about a month ago. It is available online, and I encourage you, if you want to unpack this case even further, that you could take a look at that. So with that, I will take you back a few weeks to the Gitxaała boardroom in La Clan in the village, and turn you over to Simoget Nisaiwas.
Good afternoon, everyone. My name is Nisaiwas. We welcome the whole province. Today, for me, it is unexpected to be called upon, but I'm honored and humbled to be here to share with you a victory of First Nations across the country and in the province. We're honored to be the one to be the lead. And as we begin, I'll be saying some prayer, and I remember those that have gone on before us that were with us. In particular, my late brother Cecil, the late elder Larry Bolton, and Ray Nelson. If I miss anyone, it's not intentional, but all our ancestors have been battling this for a long, long time. Our whole history has been a battle since Europeans came. And we're thankful for the legal team that has brought us through. And so we say welcome to each and every one of you. Tanishim Gigit, Sigidam Hananach, Lika Gigit, Kabawak. Shim Doyer, Shitanish no, Shimora Troilik, Shim Sagan. And Mishim Nachno, Schabo Gilder, dem Omokshe. In Lia Kako, Sta, Gitchatva. And Shim Git Go. Nach Gorum. Schudem up Shim Git Machskim, Gemal. Individuals can move and Sam's West, with the Sam's house. I'll call for a moment's silence now. We try to get them some more. You go out and get them like it's good. It's aan de hijk. Schreeuw maar lekker met oor dat kwam mee heen. Geschouw naar omhoog. Mooi nog doen de ramela houden. Ik zoek een mijn accident kom. Nog ster. Wil je mag komt ja. Hier was was het niet dat hij loyal de Germanan. Ik wil ook om God te zeggen. Want het gaat niet op niet dat het kooi. Het gaat niet op niet dat het hoogste. Er lag nog nanere. Hoi zoekje. Kun je dat gewoon bij hem om God. Ik wil ook zo wel om te zeggen. Niet kwijt zeggen nooit dat onderwijs Christ helemaal kom niet op aan. Amen.
Thank you, Nisawas. We'll now move to Gitxaała Chief Counselor Linda Innes for some opening remarks.
Thank you, Jessica. I want to begin by a quote from our elders. The land is not something we own. It is something we belong to. It carries our ayauch, our adauch, and our gugulkiansk. When we care for the land, we care for the generations yet to come. Simgigat, Siganmananach, Lucky Gabawaltik. Good day, chiefs, matriarchs, relatives, and allies. Today, we gather not just to reflect, but to celebrate a historic moment for Gitxaała and Ahadasat. The courts have spoken, and they have affirmed what we have always known. Our laws, our governance, and our rights are not frozen in the past. They are living, breathing systems that guide us today and into the future. The victory is not just a legal victory. It is spiritual, cultural, and generational. It is a reminder that when we stand firm on who we are, rooted in ayauch, adauch, and gugulkiansk, we cannot be moved. I want to raise my hands to the Simgiget, our elected officials, to our elders, and to every Gitxaała member who carried the work forward, to our legal team who translated our truths into language of the courts, and to our technical experts who showed up to demonstrate the depth of the problem. We thank you. We thank each and every one of you. This was a collective effort, and it shows the strength of unity in achieving this landmark victory. To be clear, Gitxaała has never ceded nor surrendered our territory or our traditional governance. Our governance is rooted in ayauch, adauch, and gugulkiansk. Our laws are oral history and the inheritance of our title and rights from generation to generation. These are not abstract concepts. They are the foundation of who we are and how we live as Gitxaała. Since 1859, when the Goldfield Act was introduced, the free mine entry system, mineral rights in British Columbia granted without consultation. This system allowed anyone to stake claims on Indigenous land without notice, consent, or respect for Indigenous governance. Under the Mineral Tenure Act, this continued. Claims could be staked for $1.75 per hectare with a click of a mouse, ignoring Gitxaała law and our inherent rights. For generations, this regime operated as if our laws did not exist, as if our people did not exist. The BC Supreme Court changed that. It ruled that the Crown has a constitutional duty to consult before granting claims. And now, this landmark ruling with the BC Court of Appeal has gone further. It declared that the mineral tenure regime is inconsistent with UNDRIP and cannot stand as is. The court agreed with Gitxaała. An overhaul was necessary, and reform of the Mineral Tax Act is now underway. The change is long overdue. Even in the 19th century, the Crown ignored its own laws and policies in British Columbia. They did not negotiate treaties. They simply claimed all the land and resources for themselves. For decades, the courts have urged the Crown to deal honorably with Indigenous peoples and to engage in good faith. That is what Gitxaała wants. We want the Crown to honor its obligations. We do not want to have to continue to fight in court. The mineral tenure regime should have been reformed years ago, and that is why the Court of Appeal said it is manifestly inconsistent with UNDRIP. This ruling is not just a legal technicality, it is a call for systematic change. 6 years ago, the legislature unanimously passed DRIPA to implement UNDRIP. That law says the government must take all measures necessary to align BC laws with UNDRIP. All we are saying is simple. If there's a right, there's a remedy. If we disagree about whether the law is inconsistent with UNDRIP, then the courts can order the government to consult with us and to address this issue. The courts have now decided. They have said that a mineral tenure regime without consultation is inconsistent with UNDRIP, so the government has to act. We call on BC to embrace this. They have already committed to reforming the Mineral Tenure Act. The ruling helps inform that reform. This is an opportunity not just for compliance, but for true reconciliation. When the BC court ruling in 2023 came down, the court ruled there was a duty to consult. BC did not appeal. They accepted and started working on a consultation model. I hope that when the Court of Appeal ruled, I hope that when the Court of Appeal ruled on this decision, BC would do the same thing, roll up their sleeves and embrace reconciling laws. Work with us. It is not Gitxaała law that is creating uncertainty. It is the antiquated laws such as the Mineral Tenure Act. The work ahead is at the heart of reconciliation, and we need to work on it together. So what comes next? The victory is a beginning, not an end. We will continue to assert Gitxaała law on Gitxaała lands. We will work to ensure that any future resource development respects our governance, our ayaw and our adaw. We will hold the Crown accountable to its obligations under DRIPA and the Declaration on the Rights of Indigenous People. This is about more than minerals. It is about restoring balance, protecting our lands and waters, and ensuring that our children inherit a world where Gitxaała stands strong. So we call on the government to embrace this moment, honor your own laws, DRIPA, and the commitments that you've made. Roll up your sleeves and work with us. Reform the Mineral Act in partnership with Indigenous nations. This is not about creating uncertainty. It is about ending uncertainty caused by outdated laws. True reconciliation is not just words, it is action. Let's do this work together. Thank you.
With that, with those words from Chief Counselor Linda Innes and from Simoget Misaiwas, Ruben and I will now, on behalf of the Gitxaała legal team, unpack a bit more the legal history and the legal impact of this case. And I should say just a tiny word about this partnership between West Coast Environmental Law and Fong. Fong are a very well-known litigation firm. And our role at West Coast Environmental Law, we are typically a law reform organization. And I can say I've been at West Coast now for over 30 years. And for my entire career, we have been trying to catalyze reform to this gold rush era mineral tenure law. And we always knew that a case might be required. We thought when the Ross River Dene decision from the Yukon Court of Appeal came down in 2012, given that it's essentially the same as our Court of Appeal, we thought, well, okay, it's pretty clear this is unconstitutional. We're going to see some change. And of course, I don't think it comes as any surprise that the economic and political weight of the mining sector has stood in the way. And so when the opportunity came to collaborate with Fong as part of the Gitxaała legal team, that we certainly stepped forward enthusiastically. But so Ruben and I are going to tag team a bit here. I'll be mostly dealing with some of sort of the law reform and the sort of bigger implications, and he'll be taking you through some of the nitty-gritty of the decision. So if we just bring the slides back up here, this slide really just summarizes what Chief Counselor Innes already reiterated. I really cannot stress for those of you who haven't looked at it before just how colonial and retrograde the Mineral Tenure Act is. If we go back to the Goldfields Act of 1859 and some of the language, it truly speaks, I guess you could say, to sort of the whole terra nullius piece, right? There's, the provisions that free miners can enter on the wasteland of the Crown, not occupied by anyone, to stake mineral claims that would then give them rights above virtually anyone else, speaks to the Crown's perception then, and I guess we could wonder now about essentially the denial of the existing governance and occupation of Indigenous peoples, calling their lands wastelands and unoccupied. So this has been around for a long time. You heard from Chief Innes that you can still acquire mineral rights for $1.75 a hectare, and up until very recently, until this case, just with a click of a mouse automatically. You've heard how Gitxaała had sought a review of grants of mineral claims by the Crown over particular parts of the territory. And just to sort of recap where we were in September 2023, of course, we did have a significant success at the BC Supreme Court level, with the Crown finding that the mineral claim regime violated the Crown's constitutional duty to consult. However, at that stage, the court did not grant the relief related to the UN declaration. The court was silent about the interpretive role of the UN declaration, and it refused to decide if granting mineral claims without consultation was inconsistent with the UN declaration. And that is because Justice Ross determined that the Declaration on the Rights of Indigenous Peoples Act did not create the kind of rights that could be enforced in court. It was not justiciable. And so that became the heart of the BC Court of Appeal proceeding. There were also initially some other aspects of the appeal. Of course, after the BC court decision, the court did not actually quash the mineral claims. The court left those intact in the territory and did not grant any injunctive relief. Gitxaała was able to negotiate interim protections for the territory. And right now there are legal orders which prevent mineral claim staking in the territory, as well as mining activities on Lac Nagazal. So that was resolved out of court. And that takes us into the arguments made by Gitxaała about the UN Declaration's role in reconciliation. So I'll turn it over to Ruben here.
Thanks, Jessica. Sorry, just before I begin, I was really hoping to appear in person, but I woke up sick, and just a warning, I will try not to cough into the microphone. I do have a bunch of cough drops, so just fair warning. Sorry. Yeah, so next slides are just going to go through the key issues at the Court of Appeal, starting with UNDRIP and reconciliation, and just a little bit more. It's not on the slide, but about the UNDRIP context. So, of course, this is the UN Declaration on the Rights of Indigenous Peoples, which is a declaration of the UN General Assembly from 2007. Many of you probably know this background, but at the time, it was overwhelmingly adopted by the General Assembly. There were 4 countries that voted against it, including Canada. It's not surprising who the others were, the US, Australia, and New Zealand. Canada's position evolved. I think about a year later, the Harper government did not so firmly object to UNDRIP, but it wasn't until 2016 that before the UN, Carolyn Bennett, who was then the Minister of Indigenous Northern Affairs, said that Canada was committing to adopting UNDRIP without qualification. She called it a full box of rights for Indigenous peoples, and she described it as breathing life into Section 35. And this was a year after the Truth and Reconciliation Commission, in their final report, Call to Action 43, called on all levels of Crown government to fully adopt and implement UNDRIP as the framework for reconciliation. And so Canada committed publicly and internationally to UNDRIP, and then we have the implementation statutes. So BC was the first jurisdiction in Canada with DRIPA, or the Declaration Act, in 2019. Canada followed suit in 2021. The acts are very, very similar. And there's also a Northwest Territories UNDRIP statute called the UNDRIP Implementation Act, which was passed in 2023. And so with all that background, the question for the Court of Appeal was, what does all this mean? And here's what we think. And really, when the top line on the slide there, UNDRIP is a baseline for reconciling colonialism with Indigenous peoples. One aspect being reconciling laws with UNDRIP rights. That's another way, I think, of saying that UNDRIP is the framework for reconciliation, because reconciliation is the animating purpose of Section 35 of the Constitution Act. And so how do you do this? How do you use UNDRIP for reconciliation? Well, the starting point for us anyway is that there's 2 main types of law in the colonial legal system, and that's statutes, so passed by Parliament or the legislature, and the common law, so judge-made law, case-by-case law. And practically, to reconcile laws with UNDRIP rights, you really got to address both. So with statutes, people carrying out statutory work, so administrative decision makers, be that the Chief Gold Commissioner, be that the Residential Tenancy Branch, be that professional regulators and so on, they can interpret, and indeed the Interpretation Act, we'll get more into this, but Section 8.13, at least currently, again, also for more discussion, but there's a background of the NDP proposing to amend DRIPA to remove court oversight and also amend or remove the Interpretation Act requirement. But currently, the Interpretation Act does require that all statutes in BC be interpreted consistently with UNDRIP. And with the common law, the courts have called themselves the custodians of the common law, and that really means that they can evolve the common law over time as society evolves and changes, and can interpret the common law in light of UNDRIP and consistently with UNDRIP. But the question is, what happens when a statute's language is inconsistent with UNDRIP? So you can't possibly interpret it in light of UNDRIP. And what we were saying is there must be a mechanism to bring statutory language into alignment with UNDRIP. And so these UNDRIP statutes, they all have language that affirms the immediate application of UNDRIP to laws. And the Court of Appeal has said that essentially that applies to statutes and the common law. And they all have provisions that require government, in consultation and cooperation with Indigenous peoples, to take all measures necessary, or in the Northwest Territories, it's all reasonable measures, to ensure laws are consistent with UNDRIP. So that addresses what happens when there's an inconsistent law. And the acts also have action plans to achieve the objectives of the declarations and annual reports. So in the court below, the issue was that the BC government on the DRIPA issue did not agree that DRIPA applied UNDRIP to Canadian laws, including BC laws, and they didn't agree that where a law was inconsistent with UNDRIP, a court could direct BC to consult with Indigenous governments. So that's what Jessica was talking about, the justiciability issue, and I'll have more to say about that too. So these are the issues at the Court of Appeal. So first, it's that issue of, do these declaration acts apply UNDRIP to the meaning of Canadian laws, BC laws? So for example, does UNDRIP apply to statutes? Does UNDRIP apply to the common law? And in particular, does UNDRIP apply to the duty to consult, the Crown's duties under the Constitution, Section 35? And second, at the bottom of the slide, when you can't interpret a law consistently, can a court declare that the government's duty to take all measures in consultation and cooperation with Indigenous peoples is triggered because this law, so in this case it's the mineral tenure regime, is inconsistent with UNDRIP. So now to what the court said. And the Court of Appeal, the majority, they started by setting out the legal reason for why UNDRIP affects the meaning of Canadian laws, including BC laws. The court recognized what I've already gone over, so Canada's unqualified adoption of UNDRIP at the UN in 2016, and Parliament, the federal government, enacting the Federal Declaration Act, which expressed the Canadian government's commitment to fully adopt and implement UNDRIP. And the Court of Appeal is saying that those commitments have a legal meaning. And it followed a Supreme Court of Canada decision. It's quite a prominent one. That's the First Nations Families Act reference. And at the beginning of that decision, the Supreme Court of Canada said that the Federal Declaration Act incorporated UNDRIP into the country's positive law. And so the Court of Appeal took that to mean that essentially, UNDRIP, it's not a convention. It's not a treaty with parties that entered into it with a ratification process. And that's the normal way that you see international commitments implemented into Canadian law, and there's a standard way to ratify it. But the declaration has no ratification mechanism. So instead, it's these declaration acts, and they express Canada's intention to bind itself to this declaration. And that means, according to the majority of the Court of Appeal, that UNDRIP should be applied as a weighty source for the interpretation of Canadian law in accordance with the presumption of conformity. And so that, just at the start, impacts all Canadian laws, and the Court of Appeal's analysis is not restricted to the BC Act. Because again, the logic is about Canada, the federal government, committing to UNDRIP. And presumption of conformity is what it sounds like. It's a long-standing rule of in Canadian law that domestic laws, be they statute or be it the common law, they're presumed. So of course, presumptions are rebuttable. There could be a clear intent not to follow international commitments, but they're presumed to follow Canada's international obligations. And the Court of Appeal clarified and was explicit that it applies to both statute and common law and judgment law. So even before the court is examining the language of the BC statute, it recognizes UNDRIP is no longer just a non-binding international instrument, at least from Canada's perspective. It's a weighty source for interpreting Canada's domestic laws. And so next, on the question of whether the BC Act, DRIPA, applies UNDRIP to the meaning of BC laws, the majority of the Court of Appeal says yes. Again, there's Section 8.13 in the Interpretation Act requiring that statutes be interpreted consistently with UNDRIP, and the Court of Appeal said effectively that that's a statutory presumption of conformity. And I'll actually note that all three, so this was a decision, so it's three members of the Court of Appeal, Justice Dixon and Justice Ayer for the majority, and Justice Riley in dissent. He dissented on the justiciability issue, but he agreed on this Presumption of Conformity Interpretation Act issue. And in fact, he included something more. His language is probably the strongest. He referred to this requiring an interpretation that supports the greatest amount of consistency with UNDRIP. You can see they're maximizing consistency of the province's laws with UNDRIP. So that's a unanimous decision on this point. So then, continuing with the court's analysis of the BC law, there was a dispute about certain sections. They're up on the screen there. So 2 of DRIPA has A and B. These are the purpose sections. Section 2A says the purpose of DRIPA is to affirm the application of UNDRIP to laws of BC. And Section 2B says that the purpose of DRIPA is to contribute to the implementation of UNDRIP. And the Court of Appeal said, first, 2A, the affirming the application, it doesn't implement UNDRIP, and so they agreed with the court below. It doesn't implement UNDRIP in that it creates substantive rights. In other words, as I understand it, particular articles of UNDRIP aren't now standalone laws. They're not, but it does affirm that UNDRIP is to be used by bringing it to bear on or applying it to BC laws, and that's mostly an interpretative application. The second purpose, to contribute to the implementation of the declaration, is pretty straightforward. The Court of Appeal said that's to add to the process of bringing UNDRIP into active effect. And there's also section 1.4. So what this section says is that nothing in DRIPA is to be construed as delaying the application of UNDRIP to laws of BC. And the Court of Appeal said that nothing in DRIPA delays how UNDRIP affects BC laws, either interpretively or incorporated into statutory or common laws. And again, so just to be clear on the question of whether UNDRIP applies to the meaning of common law, not just statute, the answer is yes. And that's again because, first of all, of Canada's commitments, and second, because of Section 2A of DRIPA, which does not, it says BC laws, it doesn't restrict itself to BC statutes. All right, so on to conformity. So there's some nuance here, and the Court of Appeal goes into it to some degree. In addition to UNDRIP not being a convention, so it's a declaration, and declarations are the form of an international declaration by the UN General Assembly. It's not a binding treaty, but that doesn't mean that the articles in it and the rights and obligations expressed in it are necessarily non-binding. And in fact, the question is whether or not it's customary international law. And the Court of Appeal went into this. I'm not going to go too deep into it, but essentially, customary international law is when there's a practice of states. So practice, for example, the Court of Appeal said this was a customary international law. There's a practice of consulting with Indigenous peoples about projects that affect their rights. And if your state practice is that, and then if you look at why states are practicing that, it's called opinio juris. If they're practicing it out of a sense of legal obligation, then it's binding. It's customary international law. You don't actually need to do anything further. It's part of the domestic law of the country. And so the question is like, what does that do to the presumption of conformity? And the Court of Appeal has a kind of sliding scale, but because it said that it didn't go into which rights are which, but some articles are binding, customary international law. Some might only articulate a minimum standard or an aspiration. So they're not all to be applied uniformly, but still, and this is point B here, even if it is what the Court of Appeal called a minimum standard or an aspiration, and that doesn't sound like the same thing to me, but in any case, even if it's not quite binding, there's a greater margin of appreciation, but still you're looking for general harmony, which still sounds like consistency. So it's definitely a weighty source, regardless of analysis of a particular article and whether it's binding customary international law or not. All right, on to the duty to consult. So the Court of Appeal also said, and this follows logically from their analysis, that UNDRIP applies to the common law. The common law includes judge-made law about Section 35, and so that the duty to consult is part of the common law. It's constitutional. That it applies to the Crown's obligations under Section 35. The duty to consult flows from the honor of the Crown, and that involves the assumption that the Crown intends to fulfill its promises. And what the Court of Appeal said is that Section 2A, affirming the application of UNDRIP to the laws of BC, amounts to a binding Crown promise. So the Crown is saying that it's going to act as though UNDRIP content applies to BC laws, including the common law. And while legislative action is the best route to align laws with UNDRIP, UNDRIP can and should inform the interpretation of the common law duty to consult. And just to note that the Court of Appeal didn't explicitly say that there's a presumption of conformity to Section 35 duties, but my view is such an outcome is consistent with the court's findings about the impacts of Canada's commitments and why there's a presumption of conformity in the first place. Okay, on to justiciability. It's just a little explanation of what justiciability is. And this is that issue of what happens if the law is inconsistent. You can't interpret it so that it's consistent with UNDRIP. And justiciability is about whether it's appropriate for a court to adjudicate on issues. And the court below, in brief analysis that I frankly never fully understood, Justice Ross was the Chambers judge. He looked at DRIPA and he said it didn't call out on the courts to adjudicate, but that's not the test. It's very rare for something to not be justiciable. Generally, you just need there to be a sufficient legal component. And our view, which the Court of Appeal accepted, is that a question of inconsistency between a law and UNDRIP well, the Court of Appeal said quintessentially justiciable, because you look at one legal instrument, a law of BC, and you look at another legal instrument, the UN Declaration, and you compare them, and that's the kind of thing that courts can regularly do and are expert in doing. But just as very briefly as an example of the types of things where a court has found it's not appropriate for a court to weigh in, they're looking at like its institutional legitimacy and capacity. So generally the line seems a bit fuzzy, but the line is where it looks like the court is going to be interfering in policy decisions of government. So maybe an infamous example is the Friends of the Earth case from 2008 that involved the Kyoto Accord Implementation Act. And there was an obligation to prepare a climate plan, setting out the measures Canada was taking to meet its climate commitments. And it was very policy laden. It involved cooperation with industry, with provincial actors, and so on. And that's the kind of thing where the court felt that there wasn't objective criteria. It wasn't a sufficiently legal issue. It was going to be dictating policy instead of adjudicating legal issues. And so that's the kind of thing that's not justiciable, at least according to the federal court in 2008. But here, the question is Section 3 of DRIPA. It just says that the Crown must, in consultation and cooperation with Indigenous peoples, take all measures necessary to ensure that BC laws are made consistent with UNDRIP. And the majority of the Court of Appeal, again, they said it's quintessentially justiciable. And that means a court can declare that a law of BC is inconsistent with UNDRIP. And just to be very clear about this, that's a trigger for the duty to consult and cooperate on aligning that law. And that's it. So Court of Appeal did not strike down any law. Arguably, there's no power in DRIPA to strike down anything, but it's a declaration that the government's duty is triggered under Section 3. And just briefly on this, the issue was, can courts adjudicate disputes about inconsistency? And the Attorney General of BC argued no. In Obiter, the court did identify other possible justiciable issues under Section 3. So it's up on the screen there, in addition to inconsistency. That might be the type of inconsistency. Is it something that can be addressed by Crown taking measures? What those measures are, the adequacy of consultation, or the meaning and extent of cooperation. And in dissent, Justice Riley disagreed about justiciability. He said the question of inconsistency between UNDRIP and specific laws at any fixed point in time is not a justiciable matter. what he said, it's not on the screen, but at paragraph 244, that Section 3 doesn't focus on inconsistency, that the text of Section 3, in his view, is directed towards the prospective attainment of a consistency, not on the identification and adjudication of claims of inconsistency. And that's more or less what Justice Ross, the Chambers judge in the Supreme Court, thought as well. All right, so the declaration of inconsistency and why the court made it. So the court did declare the mineral tenure regime to be inconsistent with Article 32.2 of UNDRIP. So it's quite specific. It's just to unpack that a little. This isn't a declaration that the Mineral Tenure Act itself is inconsistent with UNDRIP, but it's a combination. It's the regime, which is a combination of the Mineral Tenure Act and the regulations, which, again, as Jessica said, until after our court case had provided for no notice at all, before mineral rights were transferred for like $1.75 a hectare to third parties. So it's about the regime, and it's about 32.2 of UNDRIP. And 32.2 of UNDRIP, it's on the screen there, it requires states to consult and cooperate with Indigenous peoples in order to obtain their free and informed consent prior to the approval of any project affecting their lands, territories, and resources. And it specifically mentions mineral resources. So the Court of Appeal, the majority, was of the view that this is manifestly, the regime is manifestly inconsistent with 32.2 because of the lack of any provision for consultation and cooperation with Indigenous peoples. We will note that they hedged a bit, so they declined and didn't feel it necessary to speak more about the precise content of this international legal duty to consult, how far it goes, but they said that the existence of a duty is generally accepted as a matter of international law. So just this duty to consult under 32.2 is, in the majority of the Court of Appeal's view, is customary international law binding on Canada, and they could make this declaration. Let's slide 17. I think over to you, Jess, for this slide.
And so just to flag, I realize we're coming up on the 1:30 mark. We'll try in the next 5 to 7 minutes just to finish with the content we had, to be sure we leave some time for questions. But in these next slides, we really just want to give a snapshot of where we're at in the sort of this changing legal and political landscape in the aftermath of the decision. These were some of these were questions that have been coming up following our previous webinar. But first of all, what does the Gitxaała decision mean for the Mineral Tenure Act and BC's mineral claim regime? Now, up until Gitxaała filed their case, BC had not committed to reform this law, despite calls over many, many decades. After Gitxaała filed the case in the 2022 Declaration Act Action Plan, it was added as a priority for law reform. However, quite frankly, very little has happened since then. And so the reality now with the BC Court of Appeal decision, with the court saying that there is an obvious inconsistency between the mineral claim regime and the UN Declaration, effectively, what the decision means is that nations like Gitxaała can hold BC to account in court if they fail to consult and cooperate on reforming the law to align. And as Ruben had up on the slides just a moment ago, if the law that is eventually brought in does not align, if nations feel that BC has not taken all measures necessary to align with the UN Declaration, there is a pathway for nations to hold the Crown to account in court. And so this is critical because we all know that there is an interplay between the courts and negotiations. And so having this backstop will be very important for nations to push forward with reform to the Act. And the importance of that is emphasized by what BC did after the BC Supreme Court decision. Because rather than rolling up their sleeves, sitting down with nations and really doing that work of aligning this regime with the UN Declaration, BC unilaterally implemented what they called the Mineral Claims Consultation Framework, which is a very minimal, like, you get, nations get every 30 days, they get a batch of applications in their territory, and they have 30 days to respond. So what BC implemented was effectively not consistent even with their bare minimum constitutional duties, and clearly did not align with the obligation to obtain free, prior, and informed consent. And so this is what we see without the backstop of being able to go to court to ensure that BC is sitting down and actually doing the work that's needed to align with the minimum human rights standards of Indigenous peoples. It was sort of shone the light on that. And so although at this stage, BC has still not released publicly a timeline for reform of the Act, they do say they are still committed. So we will see about that. And I'm just realizing we probably don't have a lot of time to get into it, but Gitxaała brought forward resolutions to the Union of BC Indian Chiefs and the First Nations Summit and so on, and nations across BC have passed resolutions setting out a mandate of what they would consider to be a UN declaration aligned law. So that's available online, or we could circulate that. There's some key elements to that. For example, that free, prior, and informed consent is required at every stage of the mining life cycle, to remove legal barriers and create legal spaces for First Nations to develop and operate their own mineral tenure granting systems according to their own laws and jurisdiction, as well as dealing with some practical issues like ending the practice of, right now what happens is that once those miners click the mouse for the $1.75, they become eligible for compensation from the Crown if those rights are later affected. And that can run into the millions and millions of dollars, which creates an economic and political barrier to reform. So in any case, there is a platform that's been laid out, and we certainly hope that that will inform where we go next on that. Next slide. And this one's back to Ruben, just in terms of the landscape in litigatory landscape. That's it.
Thanks. Yeah, this is the last slide. So just quickly, so very up-to-date information here. As of yesterday, BC has sought leave to appeal to the Supreme Court of Canada. Before that, like within hours of the December decision being released from the Court of Appeal, Premier Eby announced the government's intention to amend DRIPA in unspecified ways, but we're finding out soon because consultation, I believe, is starting on a very expedited timeline. The government appears to be rushing through this, but they want to, on my understanding, not having seen any of the proposals, remove the court's ability to adjudicate claims of inconsistency. And something about the Interpretation Act. Again, haven't seen what they plan to do, but it does seem like they're responding to that by amending the laws that the Court of Appeal was interpreting. Yeah, I guess I'll leave that for discussion, but my comment there is, of course, it's ironic, especially in light of this statute. Article 19 of UNDRIP has an FPIC standard for government's legislative measures that are going to affect the rights of Indigenous peoples. But I'll leave it there for now. And we're just flagging other cases that are making their way up at the appellate level that are about UNDRIP, at least in part. First, from the Quebec court at trial level, the Montour case. So that hasn't reached the Quebec Court of Appeal yet. Anyone who's interested and hasn't read it, I highly recommend reading it. It's very long, but very interesting and very in-depth. The Montour court actually changed at the trial level, so it's going to go on appeal and likely to Supreme Court of Canada, the test for an Aboriginal right. That's the Vanderpeet test since the 90s, much maligned for a frozen rights approach. You look at the time of Crown contact and what activities were integral to the distinctive culture of the Indigenous peoples at that time, and those are your rights. Montour changed that, and they changed it because of Canada's adoption of UNDRIP. So that is continuing, and we also have Quebec. The decision from the Federal Court of Appeal is reserved, but it is coming, and that also found a presumption of conformity that applied to the duty to consult under Section 35 and free, prior, and informed consent. In that case is a consultation case about permanent nuclear waste facility. And finally, in the Dixon case from 2024 of the Supreme Court of Canada, not the majority, so two justices, and this was a case about Section 25 of the Charter. But in passing, two justices did say that UNDRIP is binding on Canada and triggers a presumption of conformity. So at least two justices have said that. We've got the federal court saying it, and we've got the Quebec court as well. So, and all of this is sort of working its way through the court system. Oh, sorry, back to you. Forgot there was one other slide.
Ruben just mentioned, and I think we want to draw attention to it again. All BC First Nations last Thursday received a notice saying BC intends to amend the Declaration Act and the Interpretation Act in the spring session, giving them 2 business days to respond. We understand that there will be less than 10 days now available, very clearly at odds, both with the BC's policy on the interim alignment of laws and with the law and spirit of the UN Declaration with respect to consultation and cooperation. And just to reiterate the point that Ruben made, a core intention of BC's actions, and this has been stated publicly, is effectively to deny access to the courts for First Nations to uphold their UN Declaration rights, their Indigenous human rights. And later in the webinar, you saw Chief Innes's remarks there. She made the point very poignantly that First Nations remember the not so recent history when Canadian law prohibited them from hiring lawyers to go to court. And I think the question here is, does the Premier really want to go back to those days? Next slide. And so just at a really practical level, when you read the media these days and you read some of the inflammatory anti-Indigenous rhetoric that's out there, you feel people asking the question, like, is the sky going to fall if we have to align laws with the UN Declaration? Is there really some nefarious economic impact that we can expect? And of course, I think Gitxaała would say no. And I think Chief Innes spoke to this, the reality that it is the uncertainty created by out-of-date colonial laws and BC dragging its feet in terms of implementation, we would say, that creates uncertainty. And I think that what we have seen is that the surest way to create predictability and stability and resilience for industry is to proceed when there is free, prior, and informed consent from nations. And some of you may have seen just recently an announcement with respect to the Eskay Creek mine by the Tahltan Nation and BC. And this is a prime example of when we see the UN Declaration working. Tahltan has an agreement under Section 7 of the Declaration Act, which provides that they need to consent to the approval of this mine, which in fact they have done. Whatever, people may have your own views about the mine, but the reality is that Tahltan approved it, and there are some very significant economic and employment benefits expected. And on one hand, BC is holding up examples like this, and at the same time, I would say inflaming the sort of rhetoric about some of the impacts. Now, one of the other things that has happened is because the Cowichan decision is another recent decision, there has been a lot of conflating of the Gitxaała decision, which really has nothing legally to do with private property rights, and the sort of being caught up in some of the perhaps we would say unwarranted fear from private property owners. But I guess maybe the short answer is that the Gitxaała case really doesn't have anything to do or doesn't affect private property and so on. And then finally, we get this question a lot. There's a lot of different industries. This isn't just about mining. What does the Gitxaała decision mean for decision-making about resource development? And I would say at a practical level, at least 2 key important things. One is that nations can raise UN Declaration rights in consultation. So yes, That includes the duty to obtain free, prior, and informed consent. But remember that the UN Declaration also contains other rights, the right to protect the environment, the right to self-determination, the rights around protection of cultural heritage, language, law, the right to choose to set the course for development in territory. So these are substantive rights that matter to nations and, of course, to all British Columbians, I would argue. So I think that maybe just go forward one more. These are, again, the Simgigit and the Skinawahana and community members in that image that just flashed up there. We were in the village for a feast celebrating the case on the weekend, and they reminded us that, yes, this is about victory in the Canadian courts, but ultimately they are here to stay and that they will continue to uphold their law and jurisdiction to defend their territories. And we are honored to serve them as legal counsel. So with that, we have a few minutes for questions and hopefully we'll be able to tackle
it. Well, I think there are some like mics embedded in the room on this very front row. So if anyone in the back has a question, please just project so that those online can hear the question in the room. And we'll also monitor the online chat to see if there are any questions. We have roughly 10 minutes. Questions for Jessica or Ruben? Very thorough presentation. Max has a question.
Hi, I'm Max, senior student at UNDRIP. I was wondering, so one thing that I've been like following a little bit is the updates to the Heritage Conservation Act in relation to there was like an issue in Saanich territory on Vancouver Island with a mountain that had significant sacred sites that were destroyed in the course of development. And under the act, what I kind of learned was that basically in order to verify that a site is a heritage site, you have to destroy the site sometimes. And so the act has all these kind of, in my opinion, horrific provisions that aren't aligned with DRIPA. And I'm wondering if like this has come up in terms of the decision of the BC Court of Appeal here potentially allowing for some kind of grounds for making sure those changes are aligned with UNDRIP and making sure that the current delay in updating the act isn't actually just like damaging those changes.
Certainly, I mean, there has been cooperative, and good work ongoing for some time to overhaul the Heritage Conservation Act and deal with some of the very long-standing issues. And I have heard different things to the extent of whether it's stalled, delayed, sort of off the rails. But the thing that I think is very deeply saddening is that the Premier seems hell-bent on amending the Declaration Act such that nations would not have access to the court to challenge whether either the current or a future Heritage Conservation Act was aligned with the UN Declaration. And that is saddening because I think we all would prefer cooperative or negotiated outcomes, but that is not always possible when one party insists on holding all the cards. So I think the answer to your question will be determined in the next few weeks and by whether the province insists on ramming through rushed and retrograde amendments to the Declaration Act and the Interpretation Act, unfortunately. I mean, the way I've sometimes heard it is like, based on the long history of denial and injustice in BC, it is very hard for nations to stomach the sort of just trust us, we'll do the right thing, because that's been proven wrong time and time again, unfortunately.
So thanks for this. I'm very curious, of course, about the forestry context. I'm on the faculty of forestry. I'm quite interested in how this would potentially have repercussions for the forestry reform, anything from transfer of tenures or other scenarios. How might this come into play?
So first and foremost, like I mentioned that one of the key things is that nations can raise UN declaration rights in consultation. I think despite the sort of soft pedaling of the court, I think it also means that the general rule, and that's language that's been used by the UN Special Rapporteur, is that nations' consent is required before approval. So that would be for tenure replacements, for cutting permit approvals, forest landscape plans, et cetera. So that would equally apply in the forestry context. Then beyond that, based on the BC Court of Appeal decision, at this stage, based on the law as it is, if a nation felt that, for example, the Forest Act provisions related to tenuring were inconsistent with nations' rights to lands and resources in the UN Declaration, the right to self-determination, any of these rights, that it would be open for a nation to bring a proceeding for a declaration of inconsistency between those laws and the UN Declaration, at which point, based on the reasoning of the BC Court of Appeal decision, there would then be an obligation on BC to consult and cooperate with nations to do that law alignment work. And if at the end of the day, it didn't cut it, to go back to court for direction. But unfortunately, this is exactly the access to the courts that BC is hoping has expressed its intention to close through legislative amendments, whether they can ultimately do that or not. So, it is profound, and yet it's the work of our time. It's yeah.
Before we get to Professor Franks' question, somebody online had a follow-up to that, so I don't know if you want to read the question aloud.
Yeah, can there be further explanation about BC's intention to deny access to the courts to uphold their rights?
Yes, well, so I will say one of the elements of the unfortunate process is that nations have been required to sign NDA so that we can acknowledge that there's a process ongoing, but can't speak to the content. However, I think the thing that the Premier has been clearest about is this desire to remove access to the courts. However, they have not yet, even under NDA, offered like specifically how they intend to do that. Yeah, sorry, I'm just trying to think how much can be said here. I think that what we know from public statements is that BC, inaccurately, I think, from our perspective, feels that there was never any intention for the commitments made in DRIPA to be enforceable in court. And I think they also, they're essentially reiterating the positions they took in court, which is that to the extent that these provisions remain, that they only apply to legislation and statutes and not to the common law, which is something that the court, and that's where we get into the question of whether the duty to consult also needs to meet the UN standard. So with apologies, I think first of all, there's some lack of clarity about exactly how BC plans to do this. And unfortunately, what we do know, we can't share. Sorry about that.
I'll ask a question to Professor Franks.
What are your, so my mind is on around paragraph 160, 161 in the decision, where it talks about the honor of the crown being a state and referring to the recent reference. And I'm curious if you could say something about how, or if you see any kind of a conversation potentially happening with BC's plan to remove access to courts in the principle of legislative supremacy in Decree 2018. And then also the honor of the Crown getting engaged by the creation of this legislation. In its first form, allowing, in the way that the court interpreted it, allowing for this to be justiciable. Does the honor of the Crown limit BC's position of potentially repealing or amending the legislation in a way that removes the right of access to the courts? So how does legislative supremacy and the honor of the Crown relate to one another?
I'll start, maybe if Ruben may want to answer. I mean, I don't think that there is an answer contained within the four corners of the decision. I think that just like sort of taking it step by step, based on just on the BC Court of Appeal ruling, if BC proceeds unilaterally or in a sort of a rushed way with amendments, it may be that is inconsistent with. I mean, the court has essentially said you can come to court and challenge that and seek declarations and guidance. I do think that the honor of the Crown, these are sort of solemn promises, would be relevant. And I think it's interplay with, in Mikisew, the court essentially said there isn't a duty to consult in its Section 35 context on legislation. And I think the implication of this decision is that, in fact, there is, whether it's either through the statutory obligation in the Act itself or by the need to interpret the duty to consult in alignment with the UN Declaration, which includes obviously Article 32.2 and Article 19 related to obtaining consent and consultation on legislation. And so I guess the way I would see it is that the honor of the Crown would be like an additional icing on the top of those arguments for why it would be essentially unlawful for BC to proceed with these amendments. So I guess I'm saying there's like the statutory piece, there's the interpretation of the common law duty, and then in addition to that, well, the additional aspect of the solemn promises of the Crown. So yeah, I think it would certainly be something we consider raising. Yeah. Ruben, did you want to add?
I don't know. I guess just very, very briefly. So this is a little abstract, but I mean, Mikisew says what it says, and in my view, there's quite a compelling dissent. But I mean, if UNDRIP applies to the common law, Montour changed the Vanderbilt test. It's going to go up to the appellate level. But there is a question of like these foundational principles of the colonial legal system, so parliamentary supremacy. But in another context that I'm also familiar with, that's these case law about Aboriginal title to like waterbed. There was an issue of whether the courts could reconcile others' foundational common law principles with title. So that's like the public right of navigation and the public right of fishing. And appellate level decisions shut down obiter remarks both in BC in the Saikaz case and in Ontario in the Chippewas the Saugeen case, that said, that the public rights, these foundational principles of the common law precluded an Indigenous right. And so I think that, implementing UNDRIP has to involve some meaningful reconciliation. And that may mean that indeed there is a duty to consult consistent with, if nothing else, Article 19 of UNDRIP on legislative measures. And I don't see why that, I don't think there's anything to be scared of with that.
And on that note, I'm just being mindful of the time. It's always just a pleasure to hear from both of you and learn so much more about the case. So we'll keep